Hello everyone, welcome to the latest Leisure Property Forum webinar on restructuring and corporate rescues. We hope the next 45 minutes will give an insightful overview of the legal and practical challenges that businesses can face when in distress. Hopefully this isn't something that becomes more prevalent in the hospitality and leisure sector post the recent budget. We've got Vernon Dennis joining us today to give a legal perspective. Vernon heads up the business advisory team at Howard Kennedy and leads the firm's restructuring and insolvency group. We've also got Ian Partridge and Grace Watman from Alex Partners. Ian and Grace provide critical advice for businesses in distressed situations and have experience advising companies, investors, and lenders in this area. We're going to start with some short presentations before moving on to a question and answer session. So over to you, Vernon.
Thank you very much, Isabel, and good morning, everyone. I've been tasked with the enviable task of giving you a brief introduction to the UK insolvency regime. I'm going to do that on the basis to give you some context of the discussion we're then going to have regarding the restructuring plans and CVAs and Cineworld, etc. And I appreciate that many of you will be familiar with the processes and procedures that we're going to discuss. But as I said, I hope to give you a little bit of context about what those processes seek to do, the way they developed, to meet potentially the sort of economic and social problems that have been encountered, and perhaps actually show that how they've developed has not been intended originally by the legislature, but has developed to meet a particular need. So if I may, next slide, please. So hopefully today what I'm going to do is run you through everything you want to know about restructuring, but perhaps we're afraid to ask. So as I said, I very much hope that this sort of introductory gives you some context as to why we have the particular procedures that we do. Next slide, please. The first and most important thing to remember around our insolvency regime is that it's a balance between particular interests. At its primary basis, it's an interest between the creditor and the debtor at one particular point. And in the particular processes, what we have is a regulation between the various creditor groups and the various stakeholders as to how they are dealt with in each of the processes. And what we have as well in the various processes that we have is a mix between the recovery for creditors and the rescue of the company for the debtors. So we have those sort of aspects of those, and the different processes we have in our current insolvency regime sort of meet the needs of those particular classes, be that the creditor, be that the debtor. The eagle-eyed amongst you will immediately spot that I have receivership put in there. And bonus points for those who will immediately recognise that receivership is not in fact an insolvency process at all. In fact, what it is it's an enforcement remedy for a secured creditor to get back their money. And when we're looking at liquidation, we're very often looking at creditors recovering their money through a liquidation process, receivers recovery, secured creditors receiving their money through a receivership process. But I've included receivership there, one, because it gives us a context as to how processes developed over time, and also because receivership is often accompanied by some form of insolvency process for the company thereafter. I will also attempt to explain why that is important in the development or otherwise of our insolvency regimes. But starting out, and let's make that clear, starting out is we've always had liquidation processes really since we've had corporates in the mid-Victorian era. And liquidation primarily was something which was compulsory. It was a court application sought by a creditor to get back their money and resulting in compulsory liquidation. Developed from that was voluntary liquidation, where the members of a company could resolve to put their company into liquidation. And we have two different types of liquidation, voluntary liquidation. One which is a members' voluntary liquidation, which is a solvent basis, and a creditor's voluntary liquidation, which is an insolvent basis. And although it says creditor's voluntary liquidation, it's still commenced by the members of the company passing a resolution to put the company into liquidation. The creditors then control the process in an insolvency situation. Moving to administration in the middle there, and I put it there quite intentionally, that has a twin purpose. One is that there is an element of rescue, and indeed the principal purpose of administration is the rescue of the company. But as we shall see as things have developed, administration is often used as a process by which there is a better realization for creditors than would be affected in liquidation, and I'll talk about that in a moment. And more recently, in our regimes, we've had company voluntary arrangement, and even more recently, restructuring plans. So if I could go to the next slide, please, what we will see is where these have fitted in. So as I've got there, we've had liquidation of receiverships, have a longer historical background to them, but I put there pre-1986, pre the Insolvency Act 1986, we had something called administrative receivership, which wasn't called administrative receivership until 1986. But what it was a development in the 1960s for lenders who were seeking to get greater recoveries by their realization or by appointing receiver. And as I'm sure most people will be aware, you're going to get more from a business as a going concern and realize more from a business as a going concern than you would from a mere business in breakup. So the lenders developed increasingly wide security, and during the 1960s created effectively an ability to take over the control and management of the company by reason of a floating charge. And that was given statutory effect by 1986. And was called administrative receivership, but I've sort of included it there before 1986 as a sort of as a prelude to say what we had as company rescue, or rather business rescue, was the banks leading the processes, the banks appointing someone to realize their security for them, the banks potentially trading the business. For often receiverships, trading and receivership were very common, and they would trade it, potentially sell it to someone new, realize their money, etc. And that's where business rescue sort of sat. The Cork Committee sat in the 1970s as a reforming body, or rather recommendations to be made for the reform of insolvency law. And it saw the virtue of administrative receivership and therefore gave it statutory effect, but also said there are a lot of companies who don't have the benefit of a floating charge. They don't have the benefit of that kind of security, allowing them some sort of ability to restructure post-insolvency. And that's how we had the creation of administration. Administration was a new procedure introduced by the 1986 Act, or rather the 85 Act and consolidated in 86 Act. And also the invention of the company voluntary arrangement. Those two processes were developed, as I said, from 1986. But two things you should remember. One, the company voluntary arrangement, certainly in its early years, probably for the first decade at least, was the bridesmaid of insolvency procedures, and very little used. We're sort of running in the 10s to 20s to 30s a year. Administration was used, but increasingly became viewed as something which was costly, procedural, because it required a court application. And that court application, and when we get lawyers involved, unfortunately, costs rise, complexity arises, and the administration procedure was seen to be useful, but could be improved if we looked elsewhere. And the looking elsewhere point came actually through the first new Labour government and Peter Mandelson going off to the States and looking at different forms of rescue, in particular Chapter 11, and deciding as a policy point that we needed a greater rescue culture in the UK. A chance for businesses to try, and a chance for a bit to try again, the chance for entrepreneurs to try again. And that led principally to reforms of the bankruptcy regime, but also reforms of the administration regime in particular. And what that introduced was something which is out-of-court administration appointments. The out-of-court administration appointments allows the company or its directors, and in reality it can be either or. So it's the company or directors can apply through simply filing at court a notice of appointment of administrators. Where they have a qualifying floating charge in place, they provide notice of intention to that qualifying floating charge holder of their intention to appoint an administrator, etc. The qualifying floating charge holder also is entitled to appoint out of court an administrator and can do so immediately. save where there's other security. So what it did is created administration as a much more, let's say, user-friendly process, and we saw a great growth in administrations thereafter. Possibly in its early days, we actually saw what would have been liquidations of the past becoming administrations, and they became quite a very useful process until to a degree, one thing that happened was costs and expenses administration, increasing court cases, making it difficult to potentially trade in administration. And I'm sure Ian and Grace might talk about administrations and pros and cons or otherwise. But one thing that did occur and has occurred over the last few years is that trading administrations have become more difficult, more costly, more risk for the insolvency practitioner in particular, and that has led to the pre-pack administration. And we will talk about pre-pack administration, I'm sure, in more depth about rescue. But principally, when you talk about administration now, a lot of people are looking at what is called the pre-pack administration. That, as I said, was something developed from the Enterprise Act from 2003, and the last sort of 20 years or so, we've seen that development. More recently is CVA, and that's the Corporate Insolvency Governance Act of 2020. CVA was a response to the COVID crisis, and there was a whole raft of reforms introduced by CVA, but CVA also made some amendments to the Insolvency Act and also to the Companies Act. And CVA and those ones, so there were some temporary reliefs and reforms of the Insolvency Act brought in by CVA, but also some full-time and ones that have stayed there on statute thereafter. And two of those procedures were ones which I would have to say had been put on the shelf. They were things that were ready, and they were ready because of the EU directive on insolvency procedures. So the EU, when we were still in the EU, was looking at making insolvency regime and providing rescue procedures, and we've seen that actually in Europe post Brexit. But we had some procedures ready to go, but hadn't enacted them. But CVA allowed us effectively that opportunity to bring those straight onto the statute, and there's two of them, two in particular. One is a new style moratorium procedure, and I have to say that is very ill used at the moment. We're not seeing a great deal of use of that. But what the moratorium procedure is where a company, it's probable that company rescue will be affected. A short moratorium can be obtained by filing of notices at court, preventing creditor action during that period of time. There's a whole raft of reasons as to why that hasn't worked in practice as well as it would expect, but we're still, but that's probably for another time. But just to say, moratorium procedure is there, but the one that has achieved a lot of publicity at very least is the Part 26 26A restructuring plan. So what we have is an amendment to the Companies Act where we have a scheme of arrangement, which we've had for some time. But the restructuring plan is a new process which has the benefits of a scheme of arrangement and has a very similar kind of process, but has something called the cross-class cram-down, which is the new and interesting weapon which can be used against creditors who dissent in those particular circumstances. And the use of that cram down has received a tremendous amount of litigation within the restructuring plans, but also a lot of publicity. But we're still running, and perhaps Ian and Grace will have the exact figure at the moment. I think we're about 30 or we're in the sort of high 30s now of restructuring plans. So they've been around a few years, but they're still not many, but they are attracting a lot of publicity, and we will be talking about those. That's the thing. But I'm really sort of saying, in terms of insolvency procedures, what you generally will see is liquidations. They account for 80 to 90% of procedures, followed thereafter by pre-pack administrations, and then company voluntary arrangements, and then restructuring plans in terms of numbers. So if I can have the next slide, I'm just going to quickly run through the effect of these insolvency regimes upon property. And I'm doing so because I'm aware that the audience is both ones who may be tenants, but also landlords. And we therefore will look at that. Prior to that, we will look, however, at how each of these processes is commenced. So what we have is liquidation. As I said, it's commenced either by the, well, it's commenced by the members, where it's a voluntary liquidation, or the creditors by application to court, where it's compulsory. And the purpose of the liquidation is simply for the realisation of the assets and then distribution of the realisations to the creditors in accordance with the statutory scheme. That's liquidation. It will see the end of the company, the dissolution of the company. There is no further steps or otherwise. Receivership, and I have here, effectively, while we still have an ability to appoint an admin receiver, that will become as rare as a hen's teeth. I don't think you will see one anymore post the Enterprise Act. But what you still have is receiverships where a secured creditor is entitled to appoint a receiver over the fixed charge that they hold over the company and realise that fixed charge subject to that fixed charge security. The purpose of that is for the realisation and return to the secured creditor alone. But it has implications and conduct for the other creditors. But remember, that's why a receiver is appointed. Administration, as I said, is out of court appointment, or alternatively, still a court appointment is available. Those who can apply for a court appointment are creditors, but also actually the company in certain circumstances might apply, and even a secured creditor with a qualifying floating charge, which might be doubtful, might apply for an administration order through a court application. But we see the vast majority of appointments now are through the out of court process. Quickly, looking at the purpose of administration, as I have already said, the primary purpose of administration is company rescue. However, company rescue through administration is very rare. The most recent stats I'd seen is about 4% of administrations result in company rescue. It is not although it's its primary purpose, if that's not what results for a whole raft of different reasons. But if company rescue is not reasonably practicable, the administrator may move on to the second objective, which is realisation of assets and distribution to creditors in accordance with the statutory scheme, better than in liquidation. It goes back to my original point of saying, well, if you've got an administrator who can sell the business as a going concern, you're going to raise more than you would in liquidation. And so if that purpose can be achieved, then administration is justifiable. Very last, if that is not reasonably practical, a secured creditor with a qualifying floating charge may appoint an administrator to realise their security still. And that's a replacement effectively of the administrative receivership point, that there is still an ability to use administration for that process. Just as a little aside, what we've tended to find over the last few years is a huge move away from creditor-led appointments. I think it's only about 16% of qualifying floating charge holders ever use their ability to appoint. The vast majority is now done through the company, its directors. It's a debtor-led process. And talking of debtor-led processes, that leads me on to CVAs and restructuring plans, which they are commenced by the company. It's a company proposal in terms of either an arrangement or compromise with its creditors. So it makes a proposal to its creditors, and they vote on those proposals. And in both instances of CVAs and restructuring plans, company rescue is the objective. It sees the company retained, not just the business. So while administration generally sees business rescue, CVAs and restructuring plans see company rescue. Next slide, please. And as I have already highlighted, I would just quickly want to talk about how insolvency interacts with property for those who are either tenants or landlords. In voluntary liquidation, in those circumstances, the landlord's rights to continue are preserved. They can enforce whatever rights they have under the lease, which is generally to forfeit. A liquidator, however, may apply to court to restrain the landlord from doing so. It would do so in very rare cases, but might do so. We've had some cases of special liquidations. Carillion was one where ultimately a special manager was appointed and steps are then taken by the court to restrain creditors from taking action. Those are pretty rare circumstances that you would use, but there are circumstances where a liquidator who can pay the rent going forward might want to retain the premises or otherwise, but very, very unlikely, very rare to see that. And importantly, where I've got it in costs and expenses, if a liquidator is retaining the premises, then they are liable for the costs and expenses that are incurred whilst they're in occupation. It's the salvage principle, a Victorian principle, goes back a long way. So in the rare circumstances where a liquidator wants to hold on to the premises, they will be liable for the costs going forward, not the arrears, but the costs going forward. More likely, and what you will see in these circumstances, is disclaimer. The disclaimer is something taken by the liquidator to effectively disclaim the tenant's interest in the lease. It doesn't destroy the lease, but it ends the interest in the lease and gives then the landlord a right to claim for the loss and damage as a result of the early termination of the tenant's rights. Effectively, it's the rent that they would have otherwise received subject to accelerated receipt as a unsecured claim within the liquidation. Compulsory liquidation is similar, but actually we have there that compulsory liquidation provides for a stay of all enforcement remedies by creditors. There is, bizarrely, to this day, there is still some debate as to whether forfeiting by peaceable re-entry is a legal process. But actually, in practice, where the compulsory liquidation occurs and the official receiver is the liquidator, they've got no real interest in the property. So as a matter of practice, the landlord is likely to take back, etc. Similar matters arise. In particular, I was talking about the special administrations. That's where you're going to see that arising here. So, sorry, special liquidations arising in these circumstances. Administration, as I said, what that does, both in terms of where a notice of intention is served or the notice of appointment, in both instances, a moratorium against creditor action and enforcement action arrives, and specifically the statute provides that includes the landlord's right of forfeiture, is prevented unless the administrator consents to that forfeiture, or alternatively an application is made to court and the court give permission for the landlord to exercise that right. There is a whole seminar one could do about that balancing act or otherwise, but that's where that lies. Importantly, the cost and expense rule works in exactly the same way as liquidation. If the administrator is using the premises for the purposes of administration, then they will be liable for the costs and expenses that are arising. They are not responsible for the arrears or otherwise. It's the responsibility as a cost and expense. Just as a little aside, just a quick one here, where we see pre-packs and pre-pack administrations, generally a sale of the business to a new party, a third party, the administrator is likely to give an unlawful license to occupy to the new purchaser of the business. And I say unlawful because it's probably prevented by the lease in itself. But then the landlord is prevented from forfeiting against the new occupier unless and until they receive administrator's consent or leave of the court. And that is a big question then about assignment and whether they're prepared to assign to the new purchaser or alternatively enter into new lease, or alternatively the administrator has to keep on paying until such time as the assignment becomes not available to anyone, in which case the administrator really ought to be giving up the occupation and possession of the property back to the landlord. A huge amount of debate stroke antagonism arises around that element, and I'm sure we'll talk about that later. The CVAs and restructuring plans do something very similar in terms of property, in as much as they can do whatever they like towards the property and or any creditors, because that's what the flexibility of both a CVA plan and a restructuring plan is. It can do what it wishes. There isn't sort of a set of rules as to what the plan ought to consist of. What it has, however, is a lot of rules about fairness and otherwise, and treatment within those processes. So provided that they can make whatever plan they like. What has occurred, particularly for CVAs around COVID, but if not a little before, to be quite frank, is the use of CVAs to compromise creditors of particular classes, and in particular the landlord classes. And so CVAs, where they once were not particularly well used, a little bit of, as I said, the bridesmaid of insolvency procedures, suddenly got a lot of publicity as they were being used to compromise landlord rights and potentially treating the landlords in a slightly different way than the other creditors, particularly essential suppliers. And there's a lot of case law which has developed, which sort of shows where that goes or otherwise. So I've sort of made the point there that arrears and future rent can be compromised within a CVA and a restructuring plan, but proprietary rights, and this has been a bit of a case law development, cannot be compromised within the plan. And that is something that Grace and Ian, I'm sure, will deal with when they talk about the fact that the landlord will be given its rights to forfeit. It retains those rights, or not forfeit, I should say, but take back possession. There's a break clause or otherwise. So it's sort of, that is sort of sacrosanct. So they can accept the proposal, they could reject the proposal, but they always retain the right in any event to take back the premises. But that sort of break clause is kind of also dealt with within the terms of the CVA. So there's a lot of negotiation, discussion with those landlords in those. And that's going to be part of our next element when we talk. Grace and Ian, I'm going to hand over to them now as they talk about these two plans and about how they can affect the landlord classes. So over to you. Thank you.
Brilliant. Thank you, Vernon. I'm just going to get our slide up that I will talk to. Bear with me one moment. Could you give me a thumbs up if you can see that? Brilliant. Okay. So as you can see, typically there are three main processes that can be used to restructure the leasehold estate of a distressed business. So going from left to right on the screen, we have a pre-packaged administration, as Vernon touched on, a company voluntary arrangement, also known as a CVA, and the newer tool of the three, a restructuring plan, which you're likely to have been hearing more and more about recently in the market. So the approach to any lease restructuring or rationalization will definitely be dependent on the company's financial position and alignment with their other objectives. The three processes, they have their own use and their own place in the restructuring toolbox. And we wanted to give you sort of a relatively high-level view with some bite-sized takeaways for each, building on what Vernon has already discussed this morning. So starting with the pre-pack administration. So typically they're used by insolvent businesses with leasehold sites that can be sold as part of a transaction. So these leases, they can be sold separately on a piecemeal basis or as a whole portfolio to either existing stakeholders or to a third party or to various third parties, following an execution of a credible sales process or marketing process. Whereas a CVA and an RP, they're very much more focused on compromising operational and unsecured debt in multi-site leasehold businesses, focusing on those leases and legacy creditors. Where a restructuring plan is slightly nuanced to a CVA is that secured financial debt can also be compromised, amended, or extended. So on to the next line. In terms of operational creditors, which of course includes landlords, in a CVA and an RP, leases and contracts can be terminated or amended. And as Vernon mentioned earlier, accrued debts can also be compromised, i.e. wiped out completely, therefore paving a pathway to a go-forward business that is profitable. In return for any of these compromises suffered, there is a mechanism whereby all compromised creditors receive a payment which makes them better off than they would be were that same company be going into an insolvency process, whether it be an admin or a liquidation. This is known as the no worse off test that you might have heard about. This is one of the biggest differences as to what is seen for unsecured creditors in an administration scenario. So unsecured creditors have an unsecured claim in an administration and typically receive a relatively small percentage of their claim in the form of a return. There are instances, however, where some creditors are deemed to be ransom creditors, and these are consequently paid in full. For example, in the event of a training admin where we might need their ongoing business for a period of time, but they're not that usual. So regarding returns for secured creditors now, they are first to recover against any assets post professional fees in an administration scenario. In a CVA, secured creditors aren't affected, as mentioned previously, whereas in an RP, secured debt can be compromised and or amended. And I'll hand over to Ian now, who'll run you through the bottom half of the table.
Thanks, Grace. Hi, everyone. So in terms of the approval and the cram down of each of these tools, I really refer to that in the context of the landlords as unsecured creditors. There's obviously consultation throughout the process, certainly with the secured creditors, the creditors that have a qualifying floating charge or a fixed charge over the assets of the company. But in terms of today, and the focus very much on the unsecured landlord creditors, in a pre-pack, highly unusual to consult with any of those landlords prior to a pre-pack. And by its very nature, it's something that attracts a lot of criticism because it does happen almost like as a surprise, because by definition, a pre-pack, it's all arranged, negotiated before it's publicly announced. So literally overnight, the administrator is appointed, and then immediately after their appointment, they execute on a sale contract, and they sell the business and assets to the new purchaser. Sometimes that can be to the existing owners. And therefore, as Vernon mentioned earlier, the good leases that the company or the owners wish to retain are then assigned, hopefully after a period of occupation under a license to assign, a license to occupy, to the new purchaser. And the bad leases, for use of a better phrase, the unprofitable leases are left behind in the entity that's now in administration. And that can be then seen as a bit of a shock, certainly to the outside world and the landlords. But it's really done to protect the business. And it was really designed for companies that have a lot of employees and important contracts, where the uncertainty of a trading administration, a public insolvency, where the outcome isn't certain, could be more damaging to the business. And that's why a pre-pack came in. There's lots of regulation around it to make sure that insolvency practitioners like me are following the regulations, and that we're following the guidelines around transparency and making sure that we're running a proper marketing process in the lead up to the transaction. We're obtaining valuations, etc. Moving on to CVA, there is obviously more consultation with creditors. They get to vote. It's a single class. All the landlords and other unsecured creditors come together as a single class, and they need to stop the CVA. They need to muster up more than 25% of that group to vote against the CVA, because you need more than 75% for the vote to pass, and that includes more than 50% of the unconnected creditors. You can't have any connected creditors forcing it through. As Vernon said, in recent years, the RP has come up. It's a new tool, and the main difference there to a CVA is that creditors are split into classes. So you can have your secured creditors and then a various number of unsecured creditors, depending on what distinguishes them from each other. Certainly in a lease restructuring, it's often you have classes based on the way that each landlord is being compromised, each landlord class. So landlords where they're landlords of sites that are being exited would be in a class of their own. Landlords of sites that are being retained and the rent compromised would be in a separate class, and they each get a vote. Again, you need more than 75% of each class voting and present to approve. However, the key difference, as Vernon's touched on, is it is possible now, unlike in a CVA, for one class to vote through and use what we call the cross-class cram down to make sure that the restructuring plan is approved. However, it is subject to very high scrutiny from the court and discretion as to fairness. The RP needs to demonstrate that the restructuring plan is better for all creditors or no worse off than the alternative. And often that alternative is an insolvency of the group. And so you need to make sure there's a fund available that is distributed to creditors to ensure that they're no worse off than they would have been in the alternative if the plan hadn't been passed and approved. With a pre-pack, there's limited court involvement, certainly where there's an out-of-court appointment. It's very much down to the insolvency practitioner to transact and satisfy themselves that the transaction is the right outcome for all creditors. And then for a CVA, again, very limited court involvement unless there's some sort of appeal. Whereas a restructuring plan, and one of the things that we'll come on to is the expense, that there's at least two times where you have to go to court. So the convening hearing, where the court hears what the plan is and the way that the classes have been set up. And then we have the sanction hearing, where once the creditors have voted, the court is presented with the results, and they then have to decide whether they're going to use their discretion to reject the plan or approve the plan. The pre-pack, as I say, very much controlled by the administrator in terms of making sure that they're satisfied that the deal's in the best interest of all creditors. The company voluntary arrangement is really a debtor in possession. The directors, it's a proposal from the directors of the company. They work with accountants, lawyers to come up with that proposal, but ultimately it's their proposal. So they're very much in control. And again, it's very similar with the plan. It's something that the company proposes to its creditors. It's not something that the insolvency practitioner dictates. The timeline, generally with a pre-pack, as long as you've got the time, the resource, that there's a marketing process leading up to that pre-pack transaction, and that's often between 6 and 8 weeks. It can be as long as 12. I've seen it shorter than 6 weeks in certain circumstances. And then, like I said before, you transact once you're in office, and it's done within 24 hours. The CVA can be within 8 to 10 weeks. There's usually several weeks of lead time where you're coming up with the proposal, doing the analysis. So it's quite a long process. And then again, the restructuring plan is much longer, especially with the preparation phase. Once you get into court, the court process is 3 to 4 months once you've had the creditor meetings, the convening hearing, the sanction hearing. Costs, it all depends on the complexity and the size of the matter, but generally the pre-pack route is cheaper because there's less court involvement and less creditor meetings. And then the CVA is cheaper than an RP because there are no real court hearings there. In terms of recent examples, these are all 3 examples where Alex Partners have been involved. Casual Dining Group, which had the Café Rouge, Bella Italia, Les Iguanas brands, they went through a pre-pack in 2020. I think one that's more recent is TGI Fridays, which very recently went through a pre-pack where certain sites were left behind, certain sites were picked up by a purchaser. It's very common, a pre-pack admin. It's generally where there's insufficient time or liquidity, cash flow to explore a CVA or an RP to achieve what they need to achieve. And then you're left with no option to survive, keep the business alive than to put it through a pre-pack when you're faced with insolvency. If you do have more time and resource, then a CVA and an RP is much more appropriate. You don't have the stigma of insolvency and the risks associated with that. And recently we did Buzz Bingo, which was Gala Bingo back in 2021. They left behind 20 odd sites, and they're now on an acquisition campaign, and they've gone from strength to strength in recent years. So the CVA for Buzz Bingo has been very successful. And then Grace and I have very recently this year been involved in the high profile Cineworld restructuring, which we can talk about at length, but I'm conscious of time. But again, it was subject to a challenge at a sanction hearing by a landlord group on a technical point around some side letters that had been entered into. But I understand that despite appeal being allowed by the judge, the landlord in question has now withdrawn that appeal. So it's fully sanctioned. There won't be an appeal. And Cineworld now on a much better, stable footing going forward, having rationalised their leasehold estate and reduced their rent burden. At that point, I'll hand back to Isabel.
Excellent. Thank you all. I think, I find that really insightful, and I'm sure many others will too. So yeah, at this stage, we'll move on to some questions. So Grace, perhaps if we start with you, what advice would you give to businesses that are experiencing cash flow pressures and are concerned they may end up in a situation where a pre-pack, a CVA or an RP might be needed in the future?
Sure, thank you, Isabel. I think the key bit of advice here is just to make sure you seek professional advice as soon as possible. The earlier a business experienced cash flow pressures speaks to restructuring professionals, the wider range of options will be available to them. Options which hopefully will allow the business to implement the least disruptive and also potentially the cheapest restructuring possible. We see over and over again that the closer a business comes to a cash crunch, the more range of options available to them diminishes. And not only that, it's also important for the directors of a business in this situation to ensure they're protecting their own personal position. There's a real risk that they, as directors, can become liable for the debts of a company if they don't pivot to taking actions that protect the interests of the creditors, especially if there's a risk of insolvency. So by taking professional advice, they can protect their own position too, as well as the company's.
Great, thank you, Grace. Vernon, have you got anything to add to that?
Yeah, I think that very good advice by Grace in terms of directors' duties, the responsibility for the debtors effectively to think about their creditors. Also, I think in terms of a restructuring element, one needs to think about what ultimate objective a business has. Ian sort of talked about that element of looking at whether a difference between a pre-pack or a CVA or otherwise. Are we looking, is the existing stakeholders, the shareholders in the business, are they committed to the business? Do they want to put more money in, or are we having to look for external funding elsewhere? And those will sort of start to dictate what processes and procedures are available as well. So I think at one point you've got a sort of the immediate cash crisis, considerations of directors' duties, things they need to consider in the short term. But there's also that sort of longer term play of, right, who are our stakeholders, who's interested? You also look to your secured lending base. How are they committed to the business or otherwise? So looking at your stakeholders, what they are, what their objectives are, how committed they are to the business going forward, also will dictate the kind of plan, the kind of proposals or plans that might be available.
Excellent, thank you. Moving on to the next question, I'll come to you first, Ian, and then Vernon, if you want to chip in with anything. Many restructuring solutions need a large professional team, extensive preparation work, much of which you've all touched on earlier. Does this limit the option for smaller businesses, and do you see any change in that going forward?
It can do, Isabel. I think really the size of the professional team involved is generally linked to the size of the business and the complexity of the situation. So often the most high profile cases that you hear about in the press, they're generally more complex and therefore they require bigger teams. But there's many restructuring processes that go on for smaller businesses where the preparation time and cost is much less in relative terms. I mean, having said that, the one process that does typically require more extensive preparation, which I touched on earlier, is the restructuring plan. Vernon mentioned earlier that I think in the 4 years that it's been available to us, we've had 30 odd restructuring plans, and maybe 7 or 8 of those have involved lease restructurings. Dobbies is currently going through a restructuring plan where they're trying to restructure some of their ground rents. But because it's a court-led process, as I've said, it requires much more extensive evidence to be prepared. And there's this risk that it can be challenged in court. It becomes much more expensive than a pre-pack or indeed a CVA. and therefore it limits the appeal to smaller businesses that are maybe more cash constrained. I think there's still some debate within the industry as to whether or not an RP will be seen to be used more widely in the mid market. There is some precedent for this. I think recently we've seen Revolution Bars, Tasty PLC, that has, as many of your members will know, operate the Dim Tea and the Wildwood brands. They've used the RP recently, and so we are seeing it. I think the way that we're going to see the RP being used more in the mid-market as time goes on, and the body of case law builds, is having more guidance around the protocol for RPs, and there needs to be a more standardized approach, not to overly commoditize it, but just to make sure that we can streamline it and be as efficient as possible, and then hopefully we'll see the cost of these processes come down.
Yeah, I would certainly agree in terms of the restructuring plan. You're quite right, Ian. There's a lot of debate at the moment as to whether they are suitable for sort of the mid-market. Even Tasty, is still quite a hefty fee for a business of that size as well. So I'm sort of quite aware of that one. I think as well, the courts have a part to play in that. We've had some judicial commentary as well through the various restructuring plans that have been challenged or otherwise at the various either sanction hearings or something, the convening meetings. They're looking towards asking for the businesses to share much more information at an earlier stage with the creditor base, and also for the creditors who have an objection to raise it early. And so if you raise it too late, you can find, as a creditor, you can find yourself in difficulty. But I would say, and I act for both sides, so I'm completely neutral, but there is also a tremendous amount of cost involved for a creditor who's seeking to get themselves involved in challenging a CVA or challenging a restructuring plan. And there's a great disadvantage for that as well. So I think the courts have a difficult job of balancing, we want the creditor to come forward, we want them involved in the process, but at the same time, trying to limit the court time and the evidence that is then required in a kind of proceeding. So I think you've got some real challenges. We will have to see how the restructuring plan, whether it can get into the mid-market, perhaps in a more available way. We have CVAs as well, and there's they are less expensive than restructuring plans, but they have their use in circumstances where you have a large creditor base which you can't otherwise reach. And Ian quite rightly says a lot of the work that we do is outside of these sort of bigger processes where you negotiate at an earlier stage with your creditor base. And if you've got a smaller creditor base, you're able to do that. Where you've got a large leasehold portfolio base, it's a very difficult thing to do in a matter of urgency. So, the context of the insolvency, who's involved, and the stakeholders all will dictate what processes are available and what costs will be incurred.
Thank you. And just looking a little more at that creditor landlord piece, it'd be good if you could go into a little bit of detail about how and when do they get to challenge these CVAs or restructuring plans?
Sure, I will do. It also goes to the point that a lot of the challenges that have happened have actually developed in the way the CVAs now work and the way the restructuring plans are working. So challenge in itself has developed the law. But let me just quickly go back the sort of two paths of challenge. In the CVA, the two paths in this challenge, and this is in circumstances where you have a creditor who is in the minority, hasn't approved the proposal, but is in that 25% and wishes to object. And they have two recourses. One is that the proposal is unfairly prejudicial, or secondly, there's been a material irregularity. I'll deal with the material irregularity a bit easier because that's generally where something has gone wrong in terms of the voting. Someone has not been put properly into their claim hasn't properly been considered or otherwise. So something procedural has happened. The bigger bit, and the one that has attracted a lot of attention and where we saw a lot of landlord challenges as the CVA was developed to deal with leasehold portfolios, is on this issue of unfair prejudice. And the courts have effectively looked at unfair prejudice on this basis. You look towards a sort of a horizontal and a vertical fairness, effectively. but horizontally, creditors are the same class, the kind of people in your thing. Are you being treated the same or otherwise? Is there a fairness? Now, there can be justification. This is the whole point. There can be justification for different treatments of creditors of the same type. A landlord and an essential supplier are both unsecured creditors, and case law is kind of developed to say, well, what is fair in these circumstances? You know, it might be fair because ultimately, if you pay the essential creditors, the business continues, you pay the employees, the business continues, where they can compromise other creditors who are not so essential in those circumstances. So that kind of unfairness isn't you don't have to treat everyone the same. You've just got to treat everyone fairly amongst that same class. And there's sort of a vertical thing is, well, what's the alternative? What would be the circumstances in your treatment in different types of scenario? And we see those kinds of challenges as well then going into the restructuring plan, and the way that the restructuring plan, and particularly the cross-glass cram down. So it's a set of creditors who are otherwise compromised where they didn't approach. And the courts look at two tests. One is, and Ian's already mentioned it, the no worse off test. So that the creditors are no worse off in the relevant alternative. So if there's an insolvency administration, you know, they are not going to be worse off. And that goes to the fact of why we're seeing restructuring plans and CVAs putting aside a pot of money, which will be distributed in the event to those creditors. That's one way of dealing with it. There's other ways of dealing with this sort of, you're no worse off in that. And you also have to evidence that as well. And the other element as well within it is the in the money test. Now, the in the money test, again, is something Ian has talked about already, but there is one class of creditor who is in the money in the relevant alternative who has approved the procedure, has then the ability to cram down. So what it's really preventing is creditors who have no real interest or otherwise in the relevant alternative, or otherwise because they're always going to be in the money, compromising those who are otherwise affected. So what it's doing is just ensuring, again, this sort of fairness or otherwise. And this is why, when you're looking at the no worse off relevant alternative test and also the treatment, you'll have the treatment thereafter in the plan. There's a lot of counterfactuals. You're trying to work out, well, what would have been the event of X, Y, Z? And therefore, a lot of evidence needs to go in to try and substantiate that they are no worse off than in the relevant alternative, and that there is an in-the-money class of creditor who is agreeing with the plan to ensure that it's fair. So there are challenges, but that goes to my point that these are sometimes quite difficult to mount and expensive for creditors to mount as well.
Thanks, Vernon, for that. So, Ian, question for you before we move on to our closing question. You touched on this earlier, actually. The recent Cineworld restructuring had that court judgment that overturned letters and agreements that were in place with landlords. These were letters that were sent out, you know, that said when they previously provided assistance and rent concessions, they wouldn't be impacted by any future restructuring plan, and that essentially got overturned. Do you think this is going to lead to landlords being a little bit more reticent about agreeing to things like this in the future?
Thanks, Isabel. I think in a word, yes, it will. I think it sent a few shockwaves through the landlord community, and quite rightly, and I understand that completely. Just in this specific case, I think I mentioned earlier that the landlord involved that disputed this and objected in court, they've now withdrawn their appeal. We don't know the reasons for that, but just for your members to know that that appeal's been withdrawn. So the decision will stand, and will be used as a precedent going forward. I think the reality is that the restructuring plans are a very powerful process, and they can override most contractual agreements as long as it can be justified and is fair. And then the judge looked at this in quite some detail around the principle of pari passu, treating people in the class equally. And with that in mind, he felt that it was fair and right that these side deals should be effectively set aside. I think landlords will need to be wary of that, and make sure that any side deals that are agreed incorporate lots of checks and balances, and access to information so that they can get the red flags, the signposts of a restructuring plan coming down the road, despite the company saying that maybe that isn't their current intention. I think whether consensual deals remain possible will depend on the nature of the business. I mean, Cineworld has had over 100 sites. And so unfortunately, one or two such mutual deals were only ever going to be unlikely to move the dial on the Cineworld's, the outcome of the Cineworld restructuring plan. It wasn't significant enough to really move the dial at all. The landlords for the large multi-site operators, like I say, are now going to be very wary. I think if the relationship between any one landlord and the tenant is particularly material to a business, then it obviously makes sense for them to explore a consensual deal, and that will have merit. And it would avoid a much more costly restructuring processes. Companies don't go into a restructuring process, be that a CVA, pre-pack RP, without deep consideration of the costs, the implications. And so there's definitely still a place for consensual deals to be had in order to avoid that scenario.
That makes sense. That's really helpful. Thank you. So just in terms of closing question, if we keep this to perhaps one sentence answers just in the interest of time, what do you think the main trends that we'll see going forward in the restructuring world are? Vernon, we'll start with you.
I think we will see continuing development of the restructuring plan, and whether that goes into the mid-market is the big question, one we've already raised. I think as well, you might also see some reform around administration. We continue to sort of see criticisms or otherwise of some of that. So MIT.
Great, thank you. And Grace, have you got anything to add there?
No, I think we certainly agree. The more RPs as opposed to CVAs, we certainly think. Also, the British Property Federation, actually, they recently called for a creditors committee meeting similar to in a Chapter 11 to be required in all RPs for standardised information to be made available. We think there's definitely some merit to that, which we might see coming into.
Great, thank you. And Ian, finally from you.
Yeah, I agree with the other points. I think the only other thing I'm conscious of is the budget announcement. We obviously saw increases to employers' NIC and minimum wage. That's going to put even more pressure on leisure operators. And unfortunately for your landlord members, one of the biggest costs is obviously rent, and to offset those increases, they're going to be looking to reduce their rent. So I do think we're going to see RPs restructuring leases more and more.
Yeah, it's certainly going to be interesting to see how everything plays out post the budget last week. So that brings our webinar to a close. I'd like to thank Vernon, Ian and Grace for their insights. I hope you'll all agree it's been some very interesting topics that have been discussed and very valuable content shared. Just as a reminder, the LPF have got lots of events in the pipeline. Our annual review is scheduled for the 22nd of January, and our flagship annual dinner for 2025 will be on the 25th of March. I would recommend getting your tickets purchased sooner rather than later, as these will no doubt sell out in advance. And thank you everyone for joining us, and goodbye.